Okay, we're back, Senate Judiciary Committee. And we're taking up S-113, which has to do with medical monitoring. And our next witness is Attorney Emily Jocelyn, who has worked hard in reaching a settlement with St. Gobain for the people of Bennington, North Bennington, Shaftesbury, and those who were former employees of the ChemFab company in Bennington area. So Emily, welcome to Senate Judiciary once again. It's like old hat. I think this is our third time on this issue. So thank you, and we're interested in hearing what you have to say.
Thank you, Senator Sears and all the other senators on the committee. My name is Emily Jocelyn. I graduated from Harvard Law School in 1982, moved to Vermont to clerk for then Chief Justice Franklin S. Billings Jr. at the Vermont Supreme Court. And then in 1983, moved to my law firm, Langrock, Sperry & Wool in Middlebury and Burlington, where I've been practicing for the last almost 40 years. In those almost 40 years, my practice has primarily focused on major environmental litigation. On behalf of ordinary Vermonters, our firm has sued International Paper Company in a federal court class action for polluting Lake Champlain with noxious air emissions and contaminated wastewater. We sued UniFirst Corporation for polluting much of Williamstown, Vermont with volatile organic chemicals, primarily TCE or trichloroethylene. Out of state, we've sued General Electric in Massachusetts and New York for their industrial pollution of PCBs in Massachusetts and volatile organic chemicals in New York, all on behalf of ordinary citizens who happen to have the bad luck of living nearby to their industrial neighbors. Since 2016, I've been one of class counsel in the federal court class action against Saint-Gobain Performance Plastics for polluting Bennington and the surrounding areas with PFOA. As you probably know, Saint-Gobain and its predecessor ChemFab operated in Bennington for almost 30 years. And in that time, the factory has emitted thousands of pounds of PFOA into the air, which rained down to the ground and contaminated groundwater and drinking water wells with this so-called forever chemical. The contaminated area is approximately 26 square miles, about 4.5 times the size of the Los Angeles International Airport, 18 times the size of Central Park. The impacts of the PFOA contamination affect approximately 2,700 residential properties and about 8,000 residents, many of whom drank PFOA contaminated well water for decades without knowledge of doing so, and have an increased level of PFOA in their blood above the national background levels. At the end of 2021, after more than 5 years of intensely fought litigation, we finally reached a $34.15 million settlement with Saint-Gobain. If that settlement is ultimately finally approved by the federal court, which will not happen until after the final approval hearing in April of 2022, the settlement will compensate property owners for their diminished property values caused by the stigma of the PFOA contamination. And for the first time in Vermont, the settlement will establish a $6 million medical monitoring program to monitor those in the class who drank contaminated water and have elevated levels of PFOA in their blood above these national background levels. These folks are at greater risk for developing PFOA-related diseases and conditions, including, but not limited to, kidney cancer, testicular cancer, thyroid disease, pregnancy-induced hypertension, and high cholesterol, among others. The program will be run out of Southwestern Vermont Medical Center by local physicians who will be specifically trained in PFOA-related medical issues. Those who have moved out of state can participate in the medical monitoring program remotely from their new locations. Senator Sears asked how the negotiations resulted in $6 million for the medical monitoring program and the remaining 26.2 million for the property diminution and property-related legal claims. Obviously, we can't disclose confidential settlement negotiations, but our decision to settle for that amount was based on the representations of our expert witnesses who will be helping to run the program, that the program could economically be managed for 15 years out of the Bennington Hospital, Southwestern Vermont, for that amount. So why, if we were able to achieve a medical monitoring program through our litigation, do we still need this bill? As I stated in my prior filed testimony in support of prior bills, first, this decision by Judge Crawford, as others have testified, is not binding on Vermont courts. But the most important issue is costs and expense. And anytime local property owners are going up against major corporations, whether an international corporation like Saint-Gobain or a more local one like others that we've litigated against, property owners injured by industrial polluters can't afford to hire attorneys and pay them by the hour or pay the costs of relevant experts, let alone all the other litigation expenses. Their opponents can and do. We took this case on a contingency fee basis, meaning that if we did not prevail, we would be paid no money and have recouped none of our litigation expenses. Our firm and the two firms associated as class counsel invested millions of dollars in attorney's fee time and more than $1 million of our own funds in litigation expenses in the hopes that we would prevail at trial or in settlement and recoup our investment. And fortunately, we expect to be able to do that. But frankly, I'm approaching the end of my working life, and I'm not sure my firm will take on another case of this magnitude. And I know few other Vermont firms capable of or willing to risk a 5+ year litigation of this sort against a huge and well-financed corporation. The costs and the risks are simply too great. That's why we need S113. So the law is clear that those injured by industrial polluters will have a clear legal right to seek a medical monitoring program as part of their remedy. These people will still need to find attorneys willing to take on the case, which may be difficult, but it will be virtually impossible without this litigation, without this legislation. In my 2019 testimony in support of S37, I explained the history of PFOA contamination in Bennington, resulting from the severe limitations in what federal and state regulatory agencies can do to protect the public from environmental harms. Despite federal statutes and rules requiring the manufacturers of PFOA, primarily 3M and DuPont, to disclose to the EPA under the Federal Toxic Substances Control Act, or TSCA, because they were creating and selling toxic chemicals, the manufacturers failed to report their chemicals to the EPA. This resulted in decades of production and use of PFOA with no regulatory oversight, either on the federal side or the state side. So when Vermont's Agency of Natural Resources and Department of Environmental Conservation was overseeing the operations of ChemFab and Saint-Gobain during their 30 years of operation and issuing permits, PFOA wasn't on Vermont's radar at all. And although ChemFab and Saint-Gobain were aware of the fact that they were using this chemical in all of its dispersions and applications, and that it was creating harmful consequences to their neighbors, they failed to report that to the federal or state regulators. So in 2016, when the state first discovered the PFOA contamination in Bennington, which, as Senator Sears said, occurred only because a well owner in Bennington heard of the PFOA contamination in neighboring Hoosick Falls and asked the state to start testing the Bennington wells. Vermont lacked a federal safe drinking water standard for PFOA as guidance for what should be safe. The Department of Health and the Agency of Natural Resources had to scramble to do research themselves, which they did, and ended up being sued by Saint-Gobain, which argued that the state's standard of 20 parts per billion was too 20 parts per trillion, excuse me, was too restrictive. The state prevailed, however, in that challenging litigation. Ultimately, as you know, the state sued Saint-Gobain and in 2 consent orders succeeded in forcing the company to pay for ongoing environmental testing to understand the extent of the contamination, and ultimately to pay millions of dollars to extend the town water lines to most homes in the Bennington area with contaminated wells that could no longer be used. This history just proves the point that state or federal regulatory agencies, as hard as they work, are not equipped, acting alone, to protect Vermonters against environmental harms. After the PFOA was discovered in Bennington, as has been discussed, this body passed Act 154, which required the formation, among other things, of a bipartisan multidisciplinary committee to review Vermont's existing environmental laws and regulations, and to make regulations to this body regarding the use of toxic chemicals in Vermont so that something like the widespread contamination in Bennington never happens in Vermont again. S113, providing the remedy of medical monitoring, is among other recommendations of that bipartisan committee. And as you know best, the medical monitoring bill has passed out of the legislature several times, only to be vetoed by the governor based on industry arguments against these bills. S113 should be passed into law. The bill establishes a legal framework to enable Vermonters exposed to toxic chemicals as the result of wrongful conduct of companies manufacturing or using them, to seek a program of medical monitoring to detect the earliest possible time any signs or symptoms of the diseases known to be associated with exposure to such toxins are detectable. The bill recognizes that Vermont companies that manufacture or purchase and use toxic chemicals are in the best position to learn and understand their likely risks. Companies that manufacture these chemicals in Vermont should reasonably be required to ensure they've explored their toxicity before using them in Vermont. Companies that purchase and use them in Vermont should reasonably be required to demand from their manufacturers sufficient information to ensure their safe use and disposal in Vermont. In the unlikely event that manufacturers fail to properly disclose such information to Vermont companies, S113 provides a right of contribution for those companies against the manufacturers when and if the Vermont company is held liable. In this way, responsibility for harms resulting from these chemicals will be borne by the companies that profited from their use, rather than placing such responsibility on their innocent neighbors or the public in general. I can take time to refute the arguments we've heard each year from the chemical and business and insurance industries as to why S113 or its predecessors should not be passed. And if I have time, I would like to do so. But first, I would like to state the obvious. Industry is well represented in the Vermont legislature and in the Vermont regulatory and rulemaking process. Ordinary Vermonters' voices, and voices like mine, I'm not a paid lobbyist, no one's paying me for testifying, are not heard often enough. My responses to the industry argument seeks to place a little weight on the scale of ordinary Vermonters when you hear those arguments. Medical monitoring, here's an argument. Medical monitoring allows people without an injury to seek relief through the courts, which would be a radical departure from Vermont tort law. Not true. Tort law has long recognized that liability for future medical care arising from a present injury is compensable. And this bill, consistent with statutory and common law remedies of medical monitoring in other states, recognizes that the impacts of certain types of chemical exposure can be proven and represent a present injury before full-blown diseases have manifested. That's the case with PFOA in Bennington. The Vermont Department of Health took numerous blood samples from residents exposed to contaminated drinking water and determined that those with levels of PFOA in their blood above the national background levels are at greater risk of developing certain diseases, which, if diagnosed early, can result in earlier treatment and better medical outcomes. The increased level of PFOA in blood is a present injury, which can be proven. But not all chemical exposure can be proven by a blood test reflecting above background levels of the substance, and national background levels have not been established for most chemicals. Other ways of measuring exposure may include risk analysis, where experts calculate how much exposure has occurred, how long someone has been consuming, breathing, or absorbing a substance at what levels, and what is the likely increased risk of developing diseases in the future. The point is that if experts can provide sufficient admissible evidence in court that someone has been exposed to a chemical as the result of another's wrongful conduct at a level which increases the risk of future disease, that is a present injury. And if there's also sufficient evidence that medical monitoring is available to address those risks, then and only then will the elements of a claim of medical monitoring be established. Another industry argument: the test of medical monitoring in S113 or its predecessors is the most lenient in the country and will lead to a flood of litigation. Not true. First, the test articulated by federal court Judge Crawford in our case is virtually identical to S113, as has already been explained. And I support the prior testimony by John Groveman and the analysis by Mike O'Grady that those differences are minor. Second, the test in this bill is consistent with that of other states. It requires admissible expert evidence on each and every one of the following elements: that the defendant acted tortiously, that is, that it violated appropriate legal standards recognized by tort law. 2, that as a result of the defendant's tortious conduct, the plaintiff was exposed to a toxic substance released by the defendant. 3, that there is a probable link between exposure to the chemical and a latent disease. 4, that the person's exposure increases the risk of developing the latent disease or diseases. 5, that diagnostic testing for the latent disease is reasonably necessary. And 6, that medical tests or procedures exist to detect the latent disease. This body should rest assured that no law firm will be willing or able to take on a medical monitoring claim and pay the hundreds of thousands of dollars in expert fees necessary to establish each and every one of the elements unless they have investigated the case thoroughly and believe the case can be proven. That is because these cases are taken on a contingency fee basis, which means that the plaintiff's attorney will not get paid either for her many hours of legal work or the expert fees her firm must advance in the litigation until she wins the case by verdict or settlement. And the courts have already established very high standards for the admissibility of that expert testimony, the so-called Daubert standard. Each expert is subject to rigorous examination, and only if their testimony is based on clearly defined methods reflecting standards set forth in peer-reviewed journals will that testimony be admissible. Even if the testimony is deemed admissible, it must make sense and be compelling to a jury, and Vermont juries can be very skeptical. So it's absolutely not the case that there will be a flood of litigation. In fact, Vermonters will be lucky if there are lawyers willing to take on these claims, even with the passage of S113. Another argument is the flood of litigation will leave little money to pay the claims of those who have developed a disease. Not true. As hard as it is to prove all the elements of medical monitoring, even under 113, it is that much harder to prove that someone has actually developed a disease as the result of the specific chemical exposure. Why? The plaintiff in such a case must meet a two-part burden under the law. First, they must prove by expert evidence that the chemical is capable of causing the disease. And second, again with expert evidence, that the nature and extent of the plaintiff's exposure to the chemical is the cause of her disease, as opposed to all other possible causes. Epidemiological studies on the impacts of chemical exposure on humans is much less common than we think. Of course, there can be no experimentation on humans, as on laboratory animals. So there is often insufficient evidence to prove the first prong of this two-part test. The second prong is even harder to prove by expert evidence, as we are unfortunately exposed to many chemicals every day. Think about pumping our own gas, absorbing secondhand smoke, drinking milk in plastic containers, inhaling chemicals from carpets, new sofas, etc. Therefore, cases alleging specific injuries from chemical exposure are relatively rare and occur in specific instances where epidemiological evidence exists, such as asbestos, lead poisoning, and stuff like that. For most people, however, their best hope for recovering for the harms caused by tortious chemical exposure will be the medical monitoring remedy, which hopefully will increase their chances for earliest detection and treatment. Another argument, the medical monitoring test is too lenient and should instead require exposure above background conditions and proof that there is a significant risk that exposure will cause a serious disease. Not true. There will not always be good statistics or peer-reviewed science on what a background level is for a specific chemical. Although there are studies reflecting so-called background levels for PFOA, there are not for the vast majority of chemicals. Moreover, much of the litigation in Bennington was over which studies and which background levels were the right ones. So restricting medical monitoring to those for which national background levels exist would be to deprive many exposed Vermonters of the medical monitoring remedy and further bog down litigation and disputes about which background levels are the proper ones on which to rely. Erecting additional legal hurdles of proving that a risk is significant or that a disease is serious will only increase the legal battles to be fought and decrease the likelihood that lawyers will take on these cases. Why? Because these terms are not self-evident or self-defining, and experts will now not only have to prove the already challenging 6 elements in the bill, but also what it means for a risk to be significant or a disease to be serious. Remember, the threshold for allowing in expert opinions in court under the Daubert legal standard is already very high. The challenge of establishing the 6 medical monitoring elements is properly significant. It is wholly unnecessary and will undermine the policy goals of this legislation to erect further barriers to establishing the claim and will only result in fewer claims and more expensive legal battles, which is precisely why the industry lobbyists wish for their inclusion. Another argument is that medical monitoring should be limited to exposure to chemicals on a specific list of toxics. Not true. As should be clear by now, federal law is already heavily weighted in favor of industry, such that under the Toxic Substances Control Act, or TSCA, it's up to the chemical manufacturer to report to the EPA that a chemical may be of concern and warrant inclusion on a list for regulation. Most emergent chemicals are on no lists, and industry lobbyists work hard to keep them from appearing on lists. PFOA was brought to the attention of the EPA in 2001 as the result of private litigation, and more than 2 decades later is still not regulated federally. As such, in other states recognizing medical monitoring, the remedy is not limited to a particular list of chemicals. Remember, the burden of proof on the plaintiff to establish, the burden of proof the plaintiff must establish for a non-listed chemical under S113 by admissible expert evidence, which meets the steep Daubert legal standard, is that exposure to the chemical can be shown by expert testimony to increase the risk of developing a latent disease. This in itself is a steep burden and a daunting one. If it can be proven, it is enough evidence that a chemical poses a threat to human health to warrant legal protection for those harmed by tortious exposure. Remember too, that companies either manufacturing or, like Saint-Gobain, purchasing and processing unlisted chemicals are in the best position, better than regulators, to know if a chemical poses threats to human health. They are required to receive and review material safety data sheets, MSDSs, which list the harms potentially arising from exposure to the chemical. And ChemFab and Saint-Gobain received MSDSs relating the harms to human health decades before they left Vermont. They are in the best position to inquire into these risks before deciding to use them in their profit-making enterprise and to do so in ways that risk exposure to others. Every incentive should be made to make sure these companies do their due diligence to ensure their workers and their neighbors' safety. They should not get a pass if their chemicals are not yet on the list. In each instance in which industry lobbyists attempt to modify the language of this or prior bills, their efforts are to insulate their clients from liability or erect steeper barriers for those harmed to recover against them. Rather than chipping away at a bill as drafted, whose language has been carefully drafted to erect fair balance of all concerns, I urge you to pass the bill as drafted and let the courts sort out the legal challenges. If, after some time has passed, there are legitimate concerns raised in court cases about the statutory language, this body can further modify the legislation. The truth is that with or without passage of 113, lawsuits brought against well-heeled companies whose industrial processes cause harm to their neighbors will continue to be David versus Goliath battles. This bill will only slightly shift the balance a little more favorably to their innocent victims, your constituents. Thank you, and I would be happy to answer any questions.
Yeah, your testimony is extremely thorough, and I wonder if you could provide a copy of that to the committee or our committee webpage. I guess as you were talking, and John Groveman, as we've gone through this bill, I'm thinking my constituents down in Pownell, who are having a very difficult time determining which industry is responsible, and many of them have gone out of business years ago. So I'm wondering about that type of case. It would seem that the state would have to take over the role of making them whole in some way, or finding an insurance company that was the insurer. Are you familiar with the Pownell case at all?
I am generally familiar, but not sufficiently familiar in order to be able to answer detailed questions. But I agree, Senator, with your analysis that because, as I understand it, of the proximity of waste facilities, disposal facilities to the town's drinking water supply, and the introduction of waste over many years by several different companies, most of which are out of business now, it would be very difficult to find the appropriate defendant or defendants for a private litigation to sue.
Thank you. Are there any other questions of Emily? Emily, thanks so much for the thorough review. And as I'm reading an email that we posted on our webpage from Sherman Joyce, president of American Tort Reform Association in Washington, D.C., who covers many of the things you just said, by the way, with statements like this broad new statutory cause of action with relatively few safeguards to protect against abusive litigation. The concern for abuse is also highlighted by several other bill provisions, including a requirement that a claimant recover his or her attorney fees in any successful medical monitoring action, and express provision stating that employees exposed to the substance outside the workplace may bring medical monitoring claims. Just so that the committee and others are aware that that's there. So thank you, Emily. Thank you, John. Hope you'll hang in there for the rest of this meeting if you can. And our next witness is Jamie Feenan, who represents, well, he'll tell you who he represents, because I've forgotten, Jamie. It's been so long since we've seen you, and it's good to have you back.
Happy New Year. Nice to see you, Senator.
Happy New Year to you too, Jamie.
And I apologize. I'm having some connectivity issues. I don't know if there's some, the winds that are going on here in Essex are contributing to that, but let me know if I start to hop in and out and I can turn off my camera.
We had that all day Monday here in Bennington with heavy winds that made me unstable, or at least the computer said I was unstable.
Exactly. The committee may prefer if I turn off my video anyway, so just let me know.
Okay.
It is Jamie Feenan with Primer, Piper, Eggleston, and Kramer this morning on behalf of the American Property Casualty Insurance Association. I believe this committee is familiar with that entity, but as a reminder, it's a national trade association comprising more than 1,000 member companies that write all lines of insurance, including several hundred who write insurance here in Vermont. I think collectively, APCIA members write about 60% of the P&C and auto market. I want to thank you, Mr. Chairman, and the committee for inviting me again to speak to this issue. Like previous witnesses, I think this is at least my third, and perhaps more, at least in this committee alone. But it is an important issue to APCIA members and helps to underscore why I'm here again today. I also want to acknowledge at the outset the revisions that are found in S113 that APCIA finds as an improvement to previous iterations of the medical monitoring bill. We think they're important and certainly support their inclusion in the bill, and I'll speak to those in a little bit. But nevertheless, they speak to the test, and APCIA continues to have concerns with some other aspects of the bill, as well as, in general, the new cause of action for medical monitoring damages. If you can bear with me, since I think other witnesses are doing the same, let me just sort of take a step back and explain why APCIA is interested in this issue and the impact it has on its development of policies that it offers to insurers. As this committee knows, insurers provide all different kinds of insurance coverage and protection from claims of liability. And this includes companies or entities whose operations or potential liability involve toxic substances. Insurers will undertake an underwriting process with the goal to match the risk or exposure with a premium that's affordable to companies and facilities and provides them the protection from said liability. Take, for example, a typical, commercial general liability policy that a business may procure. The underwriting factors an insurer undertakes will look at, the business itself, the size, condition of the premises, experience within the profession, any history of losses that the business has experienced, the type of business, is it riskier than others, for example, the location, number of employees, and any limits or deductibles that may be employed. This kind of typical CGL policy has been around for a long time. Insurers with their actuaries have become pretty good in terms of estimating price exposure in the future from liability for claims. This bill represents, of course, a new cause of action for medical monitoring damages, which poses a new risk or a broadening of an existing risk that insurers will now have to consider in writing a policy and the liability associated with that risk. So a few factors come to mind. For example, the scope of who is impacted, what type of businesses, the size of the business implicated, the likelihood of a toxic substance release, and any safety measures employed to mitigate the release, the ease or difficulty to bring this new cause of action, and the potential monetary liability in play, of course. What also adds to this complication is there's not a lot of guidance. Yes, we do now have a case in Vermont that considered this issue, but as you've heard, there are limitations on the use of the case elsewhere. We're not aware of any state statute or state that has adopted a cause of action in statute. And while there may be instances of court cases, those will be specific to the case in that particular state or jurisdictions. The unknowns or risk of liability will cause an insurer to make its own individual business decision on its appetite to take on the risk. For example, does an insurer feel comfortable continuing to provide insurance to a company impacted by this bill? Will the insurer write a new policy in this area for a company? This might leave the insured, not the insurer, to look for other commercial insurers or to the surplus lines market to fill this liability need. Historically, we can look to insurers, and in general, I think it's fair to say insurers react warily or conservatively to new risks that are presented, including when evaluating the new risk imposed under this bill. So from APCIA's perspective, narrowing the scope or mitigating those risks can certainly help in the calculation involved both from the company perspective and from the insurer's perspective. If I could turn to the bill, Mr. Chairman, unless there are any questions of me in terms of these opening general statements.
Well, we now know that the courts could act at any time, and I don't know if that provides surety to the insurer.
I think that has always sort of certainly been the case for insurers, Mr. Chairman, but I think creating a statutory cause of action elevates that awareness, right? I mean, it just creates sort of a clear and distinct path, whereas before it was through the courts.
Right.
As I mentioned, there are other aspects of the bill that APCIA has focused on in the past and continues to focus on in S113. As you know, the definitions are critically important as they become operative in the cause of action provision of the bill. We continue to believe that the definition of exposure, the definition of disease on page 2 is overly broad and prefer that it be tightened. The same is true for the definition of exposure, number 3 on page 2, which we think is again overly broad and prefer that it be in an amount sufficient to be the cause of a disease, for example. I also want to refresh my memory in terms of who is impacted by the definition of large facility. The committee's conversation earlier about the exempt entities sort of refreshed my memory that I need to do that. The mere nature that the definition is for a large facility, and yet it impacts facilities where 10 or more full-time employees have been employed at any one time. And we've certainly been talking about industrial or manufacturing facilities, but my recollection is that this list or this scope also impacts, for example, transportation, utility, sanitation sectors, et cetera. So as I say, I'll refresh my memory and provide additional update as needed for the committee. I do want to note, as has been referenced before, that we again support the provisions that have been added from the so-called Crawford decision, but the omission of the word proximate on page 6 at the very top, which is the new 4, it currently reads, as a result of the exposure plaintiffs have suffered, et cetera. We would ask the committee consider inserting, as Judge Crawford in his order had, as a result of the proximate exposure, which again sort of connects the exposure to the injury or illness for which compensation is being requested. I think the issue of attorney's fees has also come up. I won't belabor that point, but again, we think that is a provision that should be deleted. In general, what APCIA is trying to do is make sure that resources are available for claims and not expended on those with less merit. So these suggestions and the testimony is offered in that spirit, Mr. Chairman and committee. And again, I appreciate the opportunity to comment this morning. I'm happy to answer any questions you have.
Yeah, I guess one that arises for me, and it's one that I got hit with on the Senate floor one of the times that I presented this bill. If you don't do this bill, you don't have any limitations. For example, the 10-employee limit. So I understand your argument about what is a small employer, and we could argue all day whether it should be 25 or 10 or 50 or whatever. And you don't have any limit on municipalities and et cetera, and the use of pesticides. So it would seem to me that the legislation actually defines better who might be liable than trusting the courts to decide that. Just talked earlier about PCBs, and I believe it was the Burlington case at a technical center. Could they be liable? Could that technical center without S-113, but with the Crawford decision, be liable for the damages done through the PCPs to any individual. And we are limiting it to medical monitoring. And I've never understood, and maybe the insurance industry knows why. I've never understood why it wouldn't be cheaper to prevent a disease from occurring, or at least treating it early so that it doesn't become either deadly or much more expensive down the road by doing medical monitoring. I just, and these were questions asked on the Senate floor, and I guess I'm not understanding why we wouldn't want the limits that are in S-113 set by the legislature, and also why we would not want people to have medical monitoring available to them to avoid, if you don't take care of it, for example, you have a much more costly or deadly disease.
Yeah, you're bringing back, all the memories from a couple of years ago.
And I know some of them are nightmares, I'm sure.
No. And we have this conversation often, right? I mean, there are trade-offs, and I can't recall the testimony that led to the exemption for the ones that are in the bill, of course. And again, I think I'll go back to sort of a response I said earlier, in that this, for the first time, creates a statutory cause of action, right? And so that's why you hear the proponents sort of laying forth their arguments in terms of how to meet this cause of action and what the court can consider. And you hear APCIA and others sort of refute or propose alternatives to that, because the parameters to bring this cause of action is what will, of course, be important in terms of what the court considers. So if there's a low bar to bring a court case, for example, will we see that, flood of cases that you referenced in the letter from that's posted on the webpage? Is the bar higher and yet more connected to the exposure, and therefore the damages will be provided, for those susceptible to those damages? It's really sort of this discussion we're having within the box, Senator, in terms of what are the appropriate levels or parameters to bring the cause. And as indicated by the current case that we're focusing on, the courts do provide an avenue for medical monitoring damages.
Yeah, but it took 5 years, and still not sure. And several of my constituents have passed away as a result of these votes. So I guess if the monitoring had been available 5 years ago when it was first discovered, one could argue they might not have passed away as a result of this exposure. Living right in the middle of it has given me a different perspective than I might have had if I were somewhere else.
Understood, Senator.
Okay. Any other questions for Jamie? Great. Thank you, Jamie, for being with us. And everything stayed relatively stable for your internet connection. So,
well, at least we can't blame the internet connection for my stability. But
our next witness, we're going to reschedule Warren Coleman and some others at a different time. But we have Jim Sullivan, who is now famous as it is Sullivan versus Saint-Gobain now is the title of the lawsuit and a settlement. And Jim, thank you for being with us. And you've been through this every step of the way. I'm sure very frustrating. And Jim is a neighbor of mine around the corner, but unfortunately did not have access to village or town water. So Jim, welcome to Senate Judiciary, and thanks for joining us this morning.
Thank you, Senator.
Jim is also the head of our Bennington County Regional
Yes. Thank you, Senator. And yeah, maybe better to be I don't know, better or worse, but different to be famous for this than for being the leading advocate of roundabouts in our neighborhood, right?
Yeah,
So-
yeah, I know.
That's another issue.
Eventually, you'll convince me of the value of roundabouts.
In time.
We're
in
talking
time.
about the Brian Campion roundabout at the Bennington College entrance on North Bennington Road.
So again, thank you so much for having me today. I really appreciate it. I sent in a written statement to Ms. Delaney with my general perspective on this legislation. So you should have that. And I don't want to repeat that. And I'm certainly not the right person to try to parse through the legal and insurance issues that you've been hearing about from other experts today. So I just wanted to give you a rundown of our personal history, just to give you kind of a ground level view of this one particular recent situation here in North Bennington. So here it is. So my wife and I bought a lot on a hill about a quarter mile east of the former ChemFab factory in 2007. The plant had been closed for a number of years, so we didn't really give it too much consideration. We built we bought the house because the lot is really a nice neighborhood and a convenient location and a nice view. We built a house and drilled a well. As Senator Sears mentioned, we didn't have access to municipal water, so we drilled a well, which was, I think the well is about 580 feet deep actually, and moved in with 3 of our children in 2008. And of course, we all started immediately consuming water from our well in the house at that time. When the PFOA contamination was discovered a number of years later, the history of which was outlined earlier for you, our family followed the guidelines and recommendations. We had our well water tested. We had our blood levels tested, and not surprisingly, both given the location of our property, both the well water and our blood showed significantly elevated levels of PFOA. I think it's important to note and remember in the case that the ground here is going to be contaminated for centuries, and our bodies are going to be contaminated with these toxins for the rest of our lives. There's really no question about that. It's an unfortunate fact that we have to live with every day. So it's logical, in fact, it's really critical, we view, that we obtain continuous medical monitoring to determine if any of the conditions associated with exposure to PFOA and its presence in our body is starting to manifest itself in any of the diseases. So we really saw medical monitoring as being a really critical thing. Didn't know what to call it at the time when this first happened, but we knew it was something that we needed. The testing is certainly expensive. It's expensive for us. We're fortunate to have insurance through my employer, but as with most high deductible plans, the testing would cost us a lot of cash out of pocket every year. As things progressed, and we started working with the law firms, Emily Jocelyn's law firm and the others, to pursue the class action. It became kind of a leading concern that this medical monitoring program be established. And has been noted that the process has taken at least 5 years now, and it could well have taken a lot longer had we not come to a settlement agreement recently that still hasn't fully played itself out. It's been a very long process and very difficult process. I, after having been through all of this and living with this for years, and I sit back and I listen to the arguments about responsibility and liability and risk and exposure and everything else. I just have to ask myself, is like, under what possible scenario would it be appropriate for people like us to bear the costs of these medical tests and this medical monitoring that are made necessary because our bodies have been poisoned through no fault of our own? I mean, I certainly understand concerns from industry perspective and costs and risks, but our costs and risks are very immediate and very personal and very profound. And so I guess I will leave it with that. Happy to answer any questions. And like I said, I added some further thoughts in my written submission.
The written submission from Jim is on our committee page right now. So thank you for that. Are there any questions of Jim? Jim, I want to kind of follow up with your comment about, why should you be responsible for the costs of this? And I can't emphasize enough, that's kind of what somebody's going to be responsible. If it's your insurer, others' insurance rates go up. If it's out of pocket, your ability to buy other goods and services go down, or save for retirement or whatever else. Or at some point the state pays for it. And you're asking, why shouldn't the manufacturer of the product that injured you, shouldn't they be responsible? And is that substance the issue here? Somebody's going to pay, right?
That's why I ended my comments with that point, Senator. Yes, it's like there's a cost, there's a real cost and a real issue and a real impact for somebody, and we're concerned that it be equitably attributed.
So part of the reason that even before settlement, you and your family decided to seek the medical monitoring is because you want to make sure you do whatever you can to prevent a much more harmful disease from metastasizing or developing. Correct?
Yeah, that's correct. I mean, you just don't know. You know that we're living with this stuff in our bodies. It's there, it's pervasive in our bodies, and it's a fairly high concentration. And so it's a real risk that something's going to develop, and we absolutely want to stay on top of it. We have to stay on top of it. It's a responsible thing to do. So yes.
Is the medical monitoring mainly blood tests, that sort of thing? Are there other tests that you have to go through?
What we're looking at is and I haven't gone through the details of the program, but it's largely, I think, blood and urine testing, and then follow-up medical advice and consultation with doctors who are expert in the area.
Senator White has a question.
Well, I just kind of an observation, I guess, and maybe not so much of a question, but the way I understand business is that the company uses it. The company has an insurance company. Now the company is sued and they reach a settlement with their insurance company, and the insurance company pays. So what you just said, Mr. Sullivan, was that somebody's going to pay and spreading it among the other ratepayers. But my question is, why would it be spread among the other ratepayers? I know that that's what insurance companies do, but both the company that used the product and the insurance companies make profits. So couldn't there be since they really were at fault here, couldn't there be some kind of a prohibition against allowing them to spread that, excuse me, that cost among other ratepayers and instead take it out of the profits of the company and the insurance company? Am I all wrong here? It just seems to me that because they screwed up and used something really bad, that the other ratepayers in that insurance company should not be subsidizing them for the bad mistake they made. That's not so much a question, I guess. It's just I don't understand well, I don't understand the insurance business or business. So,
For what it's worth, I understand your perspective, but I don't have a really good answer for you. So
I think maybe Emily might have the best on that one when, time to, but it is the heart of the issue. Senator Nick, Emily, did you want to respond to that?
Only to say that I thought Jim was talking about spreading the increased risks of his health insurance carrier among other ratepayers. I think in this case, although certainly it depends on the defendant and their business model, in this case, Saint-Gobain was not relying primarily on insurance to pay the settlement amounts. I think it's coming out of the company itself. But, in my written comments and in my comments in the past before this committee, we've talked about how insurance rates are always indicated by industry as the primary reason to oppose any of this kind of liability legislation. I know that a lot of you were in the legislature probably a decade ago when the movie Hot Coffee was shown, which explained very well how industries together, including the so-called tort reform organization that Senator Sears referred to earlier, have spent, and the insurance industries have spent millions and millions and millions and millions and millions of dollars trying to oppose all of this legislation. Insurance rates go up anyway because, as you said, Senator White, that's how they make profits.
well, just to follow up on that, don't insurance companies sue each other also? I mean, couldn't Mr. Sullivan's health insurance company sue Gobain or the insurance carrier for them, not in this case, I guess, but I thought that insurance companies sued each other also. And I don't know.
Most litigation in courts, contrary to public perception, are companies suing each other and not individuals suing companies. When we look at court backlogs and everything else, it's usually that institutional litigation. It's true, companies and insurance companies sue each other, but it's never cheap to get into one of those battles, so they are chosen carefully.
I think Saint-Gobain is so large that they're self-insured.
yeah, and I won't speak to the insurance companies. I don't, not really well versed to that. I can speak to our insurance policy, which is like a lot of people's insurance policies. And this testing is very expensive and our deductible is pretty high. And so for us, from a very practical standpoint, this kind of testing would mean thousands of dollars a year for us. And that's real money for us.
Jim, thank you so much for joining us. Oh, Senator Nick, you had a question.
I had the same insurance company question about your Jim's health insurance company getting something out of Saint-Gobain. But I was also wondering, Mr. Sullivan, how often do you go now for the testing?
So we have some preliminary testing done after the initial blood tests were done, and we've really been waiting for the results of this medical monitoring to set the program up so that we follow the proper protocols and everything with the testing program. So other than my annual medical checkups where they do some screening, it hasn't been comprehensive per the protocols since as of yet.
I see. And was your insurance company willing to cover those tests, or did you have to work hard to get them to cover them? There's
no question that our insurance covers those things. Like I said, given the nature of our insurance policy, we pay cash out of pocket through our deductible for a lot of those costs initially, and then 30% of anything once we max out our deductible. So yeah, they cover it to the extent that it's covered.
Okay. Yeah, thank you.
Thank you. Other questions for Mr. Sullivan? Jim, thanks so much for being with us this morning and your steadfastness throughout this suit and throughout this process, a model, quite frankly, I can't say enough for my constituents who have suffered through this and have been willing to work through this process. And, one of the smaller groups are those that can't get new wells, as I must mention, or excuse me, can't get village or town water because of different problems and distance and et cetera. And so that small group will still have to have well water. And part of the settlement works with them as well. So, and this morning I learned something new. I didn't realize the area contamination is 18 times the area of Central Park. Marie Pierre is here from Bennington, and Marie, welcome to Senate Judiciary. Maybe you can tell us a little bit about yourself and your experience.
Yes, thank you. Thank you very much for having us, and it's nice to see you again, Senator
Good to
Sears.
see you again.
Yeah, it's been a while, and unfortunately, I would say because of the situation in Bennington. So, good morning, everyone. My name is Marie-Pierre Huguet, and I'm a Bennington County resident. I'm an educator, and I got a PhD in curriculum and instruction from the University at Albany. Though I studied as a teacher, I became an instructional designer, and I'm currently working remotely for a company in Texas. I design online instruction for Tier 1 universities and a training for a variety of organizations. As you might have guessed, I'm not originally from here. I came to Vermont over 30 years ago for 6 months. I never left. I fell in love with Vermont. And yeah, I got married and all that stuff, but my first love was truly this Green Mountain State. This is my home. I apologize, it's difficult.
Take your time, please.
Thank you. I consider myself a first-generation Vermonter, and as such, I am a concerned citizen who cares very deeply about what happens to my state and my fellow Vermonters. I didn't think it'd be that difficult. My husband and I built our home in North Bennington in the early 90s. He was a carpenter at the time, so he did the majority of the work himself. Fellow craftsmen helped, of course, because this is Vermont and this is what we do. We help each other, and this is why I'm here today, and so is Jim. Mid-February 2016, I was in my kitchen, putting away our dinner dishes, looking at our vegetable garden, wondering if there was anything I could get out of the cold frame, when I saw two men coming down our driveway. Richard Spieth and one of his colleagues from the Vermont DEC. They were randomly testing water from wells located near ChemFab in North Bennington. He explained that a concerned citizen had reached out to their local representative after hearing about PFOA contamination in the neighboring village of Hoosick Falls, New York. This testing was, of course, just out of an abundance of caution. This was Vermont, after all, right? No way was there any possibility of contamination. I have to say, we felt a little smug, he and I, and a little superior to our New York neighbors. I actually remember Richard and I bantering about it while his colleague was taking water from our tap. A few days later, a slightly panicked lady from the DEC called, telling us to stop drinking our water immediately and to try not to breathe when taking a shower. I don't know if you've ever tried that, but it doesn't work.
No.
Yep. The amount of PFOA they found in our well was 580 parts per trillion. The second time they did a test, more scientifically, revealed 780 parts per trillion. These were two of the highest level found in our neighborhood. More tests took place, more contamination were discovered. Our community got organized and joined a class action lawsuit. Thank you, Jim, by the way. Neighbors and friends volunteered to be class representatives, allowing their lives to be dissected and made public for the good of their community. Vermonters taking care of Vermonters. We got our blood tested. My husband had a PFOA blood level of 305 and mine was 415. I'm an educator. I'm in the classroom. That was a heck of a lot more than the 2.08 micrograms per liter accepted level. Medical monitoring was a critical part of the class action lawsuit, and after more than 5 years, a settlement was finally announced for the people of Bennington affected by the PFOA contamination. I will be one of the beneficiaries. However,
take your time.
My husband, William Sayre Sumner Jr., known by all as Sandy, will not. Sandy died on August 4th, 2021 of an undifferentiated pleomorphic sarcoma. Sandy believed very strongly that this extremely rare, extremely aggressive cancer was caused by PFOA. I know we don't know that for sure. This is one of the things that medical monitoring will help us with, collecting data and allowing us to make informed decisions about our health. Would medical monitoring have saved Sandy's life? Of course not. His was rare cancer. But had medical monitoring been in place a year or two ago, I have no doubt that we would have had more than 5 months to plan for a life without Sandy. S113 is one opportunity that we have to help protect Vermonters from going through what Bennington County went through with a PFOA contamination. It would provide them with legal recourse when directly affected by the release of toxic contaminants in their environment. I consider this to be a basic right for anyone. And I'm not sure I understand the tremendous pushback from industry towards medical monitoring. I have tremendous respect for our manufacturers. And for what they bring to our community, especially Southwest Vermont. And by the way, I have worked with some of them in some fashion in the past. I can appreciate their concern about the financial impact medical monitoring might have on them. I'm not, however, willing to give them a free pass should they not properly control toxic emissions. Why should those who get impacted by their mistakes bear the burden of the consequences? Through no fault of our own, I lost my husband, I lost my quality of life, I had to sell my home, and I will worry about my health for the rest of my life. And all I did was drink water. I do not want any Vermonter or anyone for that matter to go through what I went through. And if you need me to talk at any given time, I will speak up. We Vermonters take care of Vermonters, and I'm grateful to every single one of you for listening to us today. I would like to end my testimonial with words from my husband, spoken on June 8th, 2019. Senator Sears was there, as was Senator Campion. They held an opportunity for all of us to speak up. And that was a few days before Governor Scott vetoed the first medical monitoring bill, S-37. I sincerely hope he truly heard us today. And unlike last time, he signs the bill because it is about Vermonters, taking care of Vermonters, not the bottom line of a company driving what we do in Vermont. So this is what Sandy said 2 years ago. Governor Scott is threatening to veto this medical monitoring bill because he fears it would introduce needless complications for Vermont business. Because of political compromise, this bill, as it stands, is already weighed heavily in the favor of the business community, asking victims of chemical contamination to jump through many hoops in order to earn access to medical monitoring. Still, the governor finds it too burdensome for businesses. I actually can't believe we have to fight for this. I wouldn't want the governor or any of his loved ones to walk in our shoes. But I have to think that if he did, his perspective would be different. Let's just hope that this is not deja vu all over again. Let's get S-113 signed for the good of all Vermonters. Thank you all for listening to me today, and special thanks to Senator Sears and Campier. You truly are Vermonters.
Thank you. Appreciate that. And sorry for your loss. Once again, I know I've expressed that before. But, I do remember that day a few years ago and how strongly Sandy spoke up for the need for this legislation. I guess I was a little naive, and I've had 30 years in the State House. I was a little naive. I thought it was kind of common sense that we want to prevent worse diseases. And I have many friends in Hoosick Falls and know what many of them have gone through, and their families and the diseases associated. So thank you so much. Are there any questions for Marie here? Thank you so much for your testimony.
Thank you for listening.
Committee, I think that ends today's testimony. We'll take this bill up again one day next week. Are there any questions for Michael O'Grady or people you'd like to hear from, or issues that you would like to make sure get on the table? Senator Peru.
I really like the way the bill looks now. I think there's a very solid justification with the Crawford decision. So the one thing that I find myself wondering about is the removal of proximate, because it seems to make an argument that we're moving away from the Crawford decision in some important respect. I didn't agree with the first witness who said that it would be harder to meet the bar with proximate rather than without it. So that's my only question going forward, is on that single word, really. So anything we can do to explore that, I'd appreciate.
Anyone else with any concerns about areas of the bill you'd like to explore? Represent Senator Nick.
Just with regard to the, if you've ever employed over an unlimited period of time, more than 10 persons. Something I was worried about previously was someone who builds their own home and is their own self-contractor. You would over time, you would have more than 10 people whom you employed in just building your own home. So I think that number is low in terms of people getting into the bill. They would be in it, someone who built their own home. And if something was left there, I don't know what they would be using in building a house that could be a problem, but that's something that I think about.
I appreciate that. Let me say that I'd like at least a discussion about whether there should be any exemptions. Crawford has no exemptions. So if we followed Crawford to the letter, we wouldn't have to worry about how many of this, how many of that, or, you know, whether it's pesticides or ammunition or, you know, municipalities, they'd all be liable. So I would like to have some, as we get further down the bill, if there should be any exemptions, and if so, what should be the exemptions? Which kind of goes along with what your concern is, Alice, Senator Nick.
Oh.
Senator White.
So following up on that, I would like to have more conversation about if we were to include municipalities here. It seems to me that a local fire department using something that is traditionally used and is approved for use by fire departments is a little bit different than a manufacturer using something. And I just want to make sure that we have that conversation.
Right. But I guess that leads to a further question. If the person who used the product, for example, the firefighter, would they be liable, or the company that manufactured the product be liable?
Well, if municipalities weren't exempt, it seems to me that the fire department would be liable because they're using it just as
Right.
just as other companies use it. They didn't produce it necessarily, but they use it.
Anything else where there's question or would like further information? Well, thank you. I'd like to thank all the witnesses for their testimony this morning, and it's been very helpful to understand the differences between Crawford and 113. And